So I'm going to come back to the question of what are we doing with the title that I was given for this presentation about why and how do we need to include the Marrakesh Compact as a factor while assessing the Global Compact on refugees. So the first thing that I had to think about in respect of was, what are these objectives? Well, what are the objectives of the compacts? And here the Global Compact on Refugees is particularly straightforward. It has 4 objectives: ease pressures on host states, enhance self-reliance of refugees, expand access to third country solutions, and return in safety and dignity. When you look at those objectives, there's a bit for everybody. So the first, in easing pressures on host states, is a recognition of complaints of some states that they host far more refugees than other states. It also places the whole discussion about refugees in the context of burden, not in the context of opportunity. UNHCR has been trying for some time to get states to see refugees as an opportunity for the future, not a burden for the present. That being a burden is the result of the state's own actions, denying asylum seekers the right to work for 3-5 years while they're being processed until they're never going to get back to work, as opposed to an opportunity of people who could start working immediately, start their own business. Enhancing self-reliance of refugees. Well, that, of course, is buying into the concerns of the social affairs ministries that budgets should be limited for refugees. They should be able to take care of themselves. Expand access to third country solutions. That, of course, is very gentle speak about resettlement, about which much of the compact will be. How do we organize resettlement? And one of the things that I would say about resettlement that we should not forget is that in many European states there have been very vocal NGOs and citizens groups and religious groups that have welcomed refugees, that have not only welcomed them, but which have wanted to be able to sponsor refugees. We've seen this across local authority communities. The idea that third country solutions are a no-go area because of citizens' dislike of refugees does not actually capture what we've seen in our societies, certainly since the 2015 arrivals, when there was tremendous support. And of course, return, in brackets, safety and dignity, is there for our interior ministries, which I think Frank's work earlier today is extremely interesting, because as our interior ministries get a monopoly, the language changes to return and to this is unacceptable to our societies, we must protect ourselves against, whereas when you have foreign ministries or other ministries involved, you have other considerations at the centre. In the Marrakesh Compact, it's completely differently designed. There is no comparison between the way in which these two documents were written or how they're going to look together. It has 23 objectives, starts with data, it ends with international partnerships, but it has an overarching objective, which is safe, orderly, and regular migration. And to some extent, that call for safe, orderly, and regular migration gives some indication of what the ills that the Marrakesh Compact is designed to address, which is unsafe, disorderly, and irregular migration. I've written about that in the past. I'm not going to go into it again, but I want to go forward to our next problem, which is where is the refugee? And Audrey Macklin, who's not part of this project, but is a great colleague of Ideal's, has written in the past about the disappearing refugee. And why does the refugee disappear? Well, the refugee disappears because states choose not to recognize people seeking international protection as refugees, but prefers to give them other statuses. In the EU, we call that subsidiary protection. Now we're not calling it international protection or humanitarian status, which means they come without rights. They don't come with the panoply of rights of the Refugee Convention. So these are state choices and state policies. Will we recognize this person as a refugee, in which case they'll get a series of rights, or will we give them some kind of subsidiary protection, in which case we can decide what the rights are. And the primacy of the state then moves to looking at prevention and root causes and burden sharing and responsibility, and our institutions change. So we see this in the GRC. In the Marrakesh Convention, what is the framework? The framework is much more deeply embedded in the idea of human rights, which will give entitlements to individuals. The idea is, as set out in paragraph 15 of the Marrakesh Convention, we've got human rights there. We've got this very interesting idea of non-regression, which we haven't seen in human rights law before. It comes from other areas of law. In particular, I'm told it comes from environmental principles. But the idea that states can never move backwards. There is only one direction of travel in respect of rights for migrants, and non-discrimination. And those of us in the legal world are trying to get to grips with how the principle and the legal principle of non-discrimination works in respect of refugees and migrants. Are states entitled to discriminate between migrants in different countries, among beneficiaries of international protection and migrants, on the basis of nationality? On what basis? Is discrimination permissible or impermissible? The Marrakesh Convention isn't clear about that, but it's certainly one of the very challenging issues, and cases mention of the Convention on the Elimination of All Forms of Racial Discrimination is going to be one of our starting points. So in paragraph 15, states say, it's written in the language of we, are going to ensure effective respect and protection and fulfillment of the human rights of all migrants. We have, going back to the Marrakesh Convention and its intersection with the Refugee Convention. So as I mentioned, in the Refugee Convention, the states hold the monopoly over who gets to be recognized as a refugee. If they're not recognized as a refugee, if they're a beneficiary of international protection, then there are no rights in the Refugee Convention. Then the Marrakesh Convention on Migrants provides a very interesting possibility of sources of rights. The other thing we have to recognize is that I think the question we should ask is not why do states sign up to international refugee obligations, but who decides? Because if we let the interior ministries rush off and do international negotiations, they'd never agree to anything. But it's the foreign ministries who decide, and the foreign ministries in our national frameworks are always the biggest enemies of the interior ministries. These two ministries have completely different views of state and world. And so we see the principle of the Refugee Convention, non-refoulement, you can't send someone back, migrates out of the 1951 Convention. It migrates into the Convention Against Torture in 1984. It migrates into the Convention on against enforced disappearances in 2006. And in the EU context, it happily migrates into the EU Charter. So we see that, in fact, states are really keen on catching up with people who are not within the scope of the Refugee Convention, including them and the principle of non-refoulement in other conventions. Now, when the foreign ministries have finished signing off the documents and they've gone back and they've got ratified it all, the interior ministries then, of course, busily start putting sticks in the spokes to try and limit the protection which CAT or the Convention on Elimination on Enforced Disappearances provide. But we see that catch-up is still happening. We're seeing the incorporating of emerging protection needs that have already been mentioned here, environmental in particular, becoming a subject which will undoubtedly be captured in some kind of international convention on, perhaps in the successor of COP21. There will be, as happened in UNCAT and UNCED, a provision on non-refoulement in that context. We also have, for instance, age-related protection, children, elderly, and we have other emerging protection needs as well. Where does human rights protection take place? And here I'm going to come back to some of the issues that Case was talking about. The first is the question of legitimacy. How do standards become legitimate? And of course, here we need to think about the role of the UN General Assembly. If, as the compacts are, they're adopted by the General Assembly, are they yet then universal in a way in which, for instance, the Refugee Convention, which has to be ratified by states and actually has quite a low ratification rate in comparison with, for instance, the Convention on the Rights of the Child, what is the difference and what happens? And I think there we need to look at, for instance, the legal importance which is gradually being acquired by the Universal Declaration of Human Rights, again, adopted by the General Assembly, never ratified by any state, but frequently referred to by national courts in member states as standard setting. So who makes these rights real for people? Well, we have our parliaments through implementation. We have our public service officials in application of the implementation. And I think there's been much discussion here about, first of all, poor implementation and particularly crap application. We also have the role of jurists, both in the public service and in the private sector. So in the public service, the legal departments providing advice to the Interior Ministry, saying, no, actually, that is going to be inconsistent with our obligations. We have our jurists in private practice or in NGOs working for individuals seeking protection. We have our NGOs who are providing political activism. And then we have our judges who have the final word. We also have the issue that we'll have to look at in the context of the compacts of UN human rights bodies and the regional shadow. We're going to be looking at Europe in particular. And we have seen that our regional institutions in Europe have been extremely noisy internationally. There is not a human rights body around the world that isn't aware that there is a European Court of Human Rights. And you see in pleadings by NGOs at the national level, scattered across the world and far out of the English-French language groups, using references to the judgments of the European Court of Human Rights. So very noisy actor out there on the regional level setting human rights standards. We have in the shadow of that rather noisy actor the UN institutions, in particular the treaty bodies responsible for interpreting the UN human rights treaties and the optional jurisdiction. There we have the great argument that goes on in particularly among states that are who are not particularly thrilled with the idea of supranational courts, claiming that there's a profound difference between judgments of the European Court of Human Rights or the Inter-American Court of Human Rights and opinions of the treaty bodies, and then the role of general comments of the treaty bodies as advice. So coming to towards the end of this presentation, what is the value of human rights for refugees? Well, we have the force of international measures. So where do they apply? Who gets to get them? I've used the idea of the Universal Declaration. Case has already mentioned the example of the UNHCR handbook. How do rights become incorporated so they become available to people, including refugees, beneficiaries of international protection, on the ground? And what is it that makes these measures visible and accessible? And I've looked at some of the actors who participate in making visible and accessible these rights for individuals. And there is one more institution that I want to comment on, which this is the role of states among themselves. What value does the UN's Universal Periodic Review have? This new toy that was developed with the new millennium for the UN, where it was peer-to-peer, because countries didn't want to be judged by courts and judges or some kind of academic body out there. They wanted just to have peer review among themselves, peer-to-peer review. Universal Periodic Review was the result of that. But when we look at the outcomes of Universal Periodic Review, in the preparation, the civil servants in the UN pull together all the comments of the special rapporteurs, of the treaty bodies, of every UN-related agency relevant to the human rights record of the state under review. This information is digested in various ways. It is then used by the states that are carrying out the periodic review of the state under review with the questions which are posed. And if you look, the United States is up for Universal Periodic Review in this session. It's taking place now as we are here. And if you look at the questions, which are always publicized in advance on the website, you will see very interesting questions from a number of states on the question of migrants, expulsion, separation of families, very much harsher questions in the peer review than would ever have happened from, for instance, the Human Rights Council. So there is a space there, I think, to incorporate both of these global compacts into Universal Periodic Review as part of the commitments which states have undertaken in respect of how they are going to behave in respect of refugees and migrants. So I think there is space for people, but I think it is multi-layered and complex. Thank you very much for your attention.